Setting up an estate plan for clients, there are many tools in the estate planner's arsenal. It's not necessarily just accomplished through document creation, either wills or trusts or powers of attorney. It also is an asset designation, an agreement. Wanted to give the basics of beneficiary designations as an estate planning tool, rather than just relying solely on a will or trust or to accomplish estate planning objectives. An alternative is to rely solely on beneficiary designations to accomplish your end-of-life goals. Beneficiary designations can be a helpful tool in estate planning, so wanted to give a breakdown video of the 411 of relying on beneficiary designations to accomplish your estate plan, the pros and cons of relying solely on beneficiary designations. Just about every account allows you to designate a pay-on-death designee, which is also known as a beneficiary designation. They could also be referred to as PODs, TODs, which is short for pay on death or transfer on death, but I'll refer to them in this video as beneficiary designations. If you have a beneficiary listed on every one of your accounts, every parcel of real estate, then probate can be avoided because those designations operate as a matter of law. You're prearranging legally for the distribution of each asset one by one when you designate beneficiaries. What that means is that if you write a will or a trust that says you want the property to be distributed according to a plan written in the will, that will not be carried out on an asset that has a beneficiary, which is an important fact to note. It's an alternative to estate planning. The benefits of beneficiary designations, the strongest one is how cost-effective beneficiary designations are. They don't require an attorney, and it's an action that you can do on your own to go out to each one of your accounts and designate a beneficiary. Except for real estate, it's very important to have an attorney or a title company put together deeds for real estate if you are wanting to convey those to a beneficiary. However, putting a deed together is traditionally much cheaper than establishing an estate plan where you put together a will or trust. The other benefit is that if everything goes smoothly, they can be a simple option. That it is instructions to the bank to write checks to or distribute the ownership to your beneficiaries. There aren't any questions asked. That once an institution gets a death certificate, they write a check. Which leads into one of the drawbacks, is it doesn't allow for nuance. Some of the drawbacks come with the oversimplification of estate planning. Because you're writing instructions to distribute money directly to the beneficiaries, no money is set aside to be held for costs of your administration. So it doesn't answer the question, how is the funeral bill going to be paid? How are taxes going to be paid? What if we need to hire an attorney to assist with some side matter with your estate? Or what if the house requires upkeep before it's sold? Maybe foundational issues are discovered which costs a significant amount of money before you can list the house before it's sold. With beneficiary designations, nothing is written down or legally enforceable to ensure that your costs of administration, whatever it may be, is paid for first before your beneficiaries get the money. Generally, I don't recommend relying on beneficiary designations unless the client's willing to assume the risk. Even if you have one child or a single beneficiary who is intended to receive all of the property, you have to assume the risk that the beneficiary you've designated is going to survive you. If they don't, this designation falls apart. The point of a will or trust is to write it down and cover the contingencies, ensuring that your estate, your money that you leave behind is first used for your costs of administration, whatever costs that may arise, before it's distributed to the intended beneficiaries. And it's meant to cover the conditionals. What if any of the beneficiaries are deceased? What if they're incapacitated? What if they're addicted to drugs? What if they're spendthrifts at the time or on Medicaid if they're incapacitated? Wills or trusts allow for the nuance and the conditionals where beneficiary designations really tends to fall apart. So it can be useful because of its simplicity and ease of implementation, but can fall apart. However, it has the drawbacks of not allowing for any sort of complexity.